Hey, Happy New Year, everybody. First episode of 2025. Welcome back to Chalk and Gavel.
Officially 3 years of Chalk and Gavel now.
Well,
we started in 23.
Yeah, I don't, that's a little misleading. Wouldn't you say?
It's very misleading. Yeah.
We had like 3 episodes in 2023.
But we still released Chalk and Gavel in 3 years.
In 3 years, yes. We're still here, folks. We're not going anywhere. You haven't gotten rid of us yet. So welcome back, 2025. Here we go. We've got a great case for you today. But before we dig into it, just a few points of order. We would love it if you would rate and review Chalk and Gavel on your favorite podcast platform. We also have a great feedback form on our website. We would love to hear from you and hear about different ways that we can make this show a little bit better.
Also on our website, you can find a link to our teaching guide. So if you are looking for education law content for your courses or professional development, you can go to chalkandgavel.com. And lastly, if you're looking for other ways to engage with the show, please consider supporting us on our Patreon. So for just $2 a month, you can help us continue to deliver the education law content you've known and loved for 3 years now. But your support absolutely means the world to us. So please consider going to patreon.com/chalkandgavel.
Yeah, help us keep this show going. All right, let's get into it.
Do students have First Amendment rights to avoid potentially controversial school assignments and activities? When does a school assignment cross the line between legitimate educational activity and being inappropriate? Should school assignments come with a disclaimer?
I tell you what, this episode might need one of those disclaimers.
It just might.
It might get a little raunchy, folks. Yeah, so...
That's the subject matter. That's not Jamie and I.
We do a pretty good job of restraining ourselves, but the content of this particular episode could get a little dicey.
So
like that? That was a Las Vegas joke. I'm getting ahead of myself.
I was going to say, you should tell them where this takes place first.
I know.
Yeah.
There's going to be a lot of that in this episode. So, yeah, this is an episode that's out of Vegas, and so you might have some Vegas and gambling jokes thrown in here. Yeah, so it might get a little dicey. So this one is a really interesting case. We think they're all interesting, but for you teachers out there, and principals too, this one is really, really quite the case. Today's case is about a Las Vegas high school drama teacher who rolled the dice and asked students to write a monologue and have them performed in front of the class. So buckle up for some more Vegas jokes here. The twist, in this case, or the river, I guess.
Okay, I see. That was good.
It's
Texas Hold'em joke. Yeah.
I know, it's a stretch. So the twist is that the teacher asked students to randomly pick another student's monologue to perform in front of the class. And well, one of those monologues was sexually explicit, shall we say? Or shall the court say?
We'll let the listener decide.
Exactly. So, feeling compelled to complete the required activity, one student read that monologue, and things flopped from there. That was another Texas Hold'em.
Yeah.
Another stretch. I know.
You should fold.
Folks, if you haven't gotten used to this by now, so I'm really glad we're doing this case. This is a really great, interesting, and complex case that is so important for teachers and administrators to hear, I think at least. So here we go. This is the 2024 case of Evans versus Hawes.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Jamie, got a bell ringer for us?
I do. All right. Today's bell ringer. This is a follow-up to our episode 29 bell ringer.
Another follow-up. Look at us following through.
I know, we do lots of follow-ups. Yeah. So this is a follow-up to two episodes, actually. An episode 29 bell ringer that we did, and the case that we discussed in episode 14, which was the Coalition for TJ case. So you might recall that both of those cases, the bell ringer case and the Coalition for TJ case, those dealt with selective schools admissions processes. Okay, so in both of those cases, the TJ case, which was out of Virginia, and the episode 29 bell ringer, which was a case out of New York, they had to do with these selective public schools modifying their admissions processes, and those modified processes essentially changed the demographic makeup of the school.
Right. Because they were looking to increase diversity at these selective schools.
Yeah.
They
exactly.
fiddled with the admission processes. So, like, I remember the TJ case, like, they took some of the tests, they emphasized enrollment from under-enrolled middle schools, that sort of thing.
Yeah. And so basically in both of those cases, the number of Asian American students decreased. All of this is really interesting in light of the recent affirmative action Students for Fair Admissions case.
Right, the Harvard case that struck down affirmative action in higher ed, yeah.
Yeah. So that, more or less ruled that the extent to which these higher ed schools used race as a factor in admissions was essentially unconstitutional, right?
Right.
So we've covered these cases because the U.S. Supreme Court hasn't really weighed in on these similar kinds of situations from the K-12 arena, right?
Right. We're just kind of waiting for that.
Yeah. Well, we're going to have to wait a little
bit longer. Yeah.
So in episode 14, we talked about that TJ case, and the Supreme Court declined to hear that case, which left the lower court opinion in place. And that opinion was essentially that it ruled in the school district's favor, right? And Alito and Thomas were none too thrilled about that case not making it up.
I remember Alito had some choice words to say about the reasoning of that decision.
Yes. He's nothing if not consistent.
Oh, yeah?
Yeah, because he had some choice words to say about today's bell ringer as well. Not the actual bell ringer, but the case that the bell ringer is on.
Right. Oh,
I don't think he listens.
Do you think he's a listener?
I don't know. I
hope not, actually, because we say some ungenerous things about him occasionally.
Yeah. I agree. Yeah, so that was the TJ case. The U.S. Supreme Court decided not to take that up. In the New York case that we talked about a few episodes ago in the bell ringer, a district court initially ruled mostly in favor of the school district. Recently, a federal appeals court revived the lawsuit, allowing it to move forward, which is why we kind of talked about it in the bell ringers, because it has the potential to go in a different direction than the TJ case went. Right. So the reason why we're dredging up all, the past here is because when we talked about the New York case a few episodes ago, we mentioned that there was another similar case happening out of Boston. Well, that case involved challenges to the admissions plans at 3 elite public schools, and in early December, the Supreme Court declined to take up that case as well.
Okay, so same thing that happened to TJ.
Yeah.
School wins.
Yeah.
There's no unconstitutional, racial preferencing or racially discriminatory intent, or, whatever grounds the school won on, gets up to the Supreme Court. Supreme Court says, we're not going to touch that now.
Exactly.
Okay.
So at the heart of all of these cases is whether or not these policies are essentially race neutral, and the resulting changes in demographics are largely because of other factors, like changing, like you said before, like changing the criteria around which schools or zip codes are considered in the admissions process, and how, and all of that stuff. So whether or not these policies are actually discriminatory is a huge part of the question, right?
Right, yeah, because the question is, are you using race-neutral means to accomplish your goal of diversity? And is that goal of diversity, are you motivated by this impermissible discriminatory intent to, basically, use race as a deciding factor?
Yeah. So in TJ and this Boston case, they couldn't really show any discriminatory intent, so the schools came out ahead, right? In the New York case, that recent appeals court decision said that there may be discriminatory intent there, they said the case
kicked it back, yeah.
Yeah. So here we are. This is the second time in less than a year that the Supreme Court declined to take up this kind of case.
Which is really interesting that it came up again that fast.
Right. Exactly. And similarly to the TJ case, like we said, Alito and Thomas were, again, none too thrilled.
Nothing if not consistent, as you said.
That's right. So now the court in this case, and in most cases, didn't give a reason for not taking up the case.
Right. They will rarely ever give a reason for not taking up a case.
Right. But our friends were not shy about giving reasons for their disapproval of that move.
Sometimes you'll get people who say, hey, we should have taken up this case, which is what Alito wrote the opinion and Thomas joined it.
Yeah. Well, they didn't say it. I wouldn't say they said it as sort of casually as we should have taken up this case, because here's exactly what Alito wrote.
No, I imagine it's a bit more cantankerous. Is that the word I want?
Listeners, you be the judge. Here's what he said. Quote, "We have now twice refused to correct a glaring error that threatens to perpetuate race-based affirmative action in defiance of students for fair admissions." Unquote. I probably added emphasis, like he wrote that, so I don't know where he wanted the emphasis, but I was sort of editorializing emphasis there, but I think I got it pretty close.
I think so.
He also called these policies, quote, racial balancing by another name, unquote. And this is what I find kind of interesting, because whether we agree with the Students for Fair Admissions decision or not, what is basically being done here is we're being told we can't have race be an explicit factor in admissions, right? At least that's what the Supreme Court has told us.
And racial diversity can't be like your goal.
Right. So in some of these K-12 cases, the courts are looking at exactly that question and determining that race is not a factor. Right?
Right. It's really like this is so
it's
complicated, right?
Yeah.
Because there's so many different ways to think about what is happening here. And, I think one of Alito's big arguments is that the way that we infer whether or not there's a discriminatory intent, we need to look at the impact that has and like the changes that happened between policy A and policy B. Because that was one of his big critiques with TJ is like we basically didn't look at how the enrollment changed relative to the old policy. Because remember there was that huge conversation about like whether or not we are enshrining the status quo into like constitutionally protected status. But like there's this other point about like the Supreme Court has been really permissive or like has actually encouraged folks to pursue diversity through race neutral means in other cases.
Right.
And now we've got this, Alito seems to be kind of suggesting like, hey, that's just racial balancing by another name. We need to rethink that too.
So, yeah, and that's the sort of interesting thing about this to me is that it's almost like they're going backwards, right? We're looking at the end result and trying to find a problem with the intent as opposed to starting with let's look at the intent, right? And not necessarily concern ourselves with the outcome necessarily as long as the intent is okay.
Well, and that's the thing is like, there's two ways to prove intent. You can prove like, direct discriminatory intent either like facially or based on like something somebody said, or you have to infer it from the circumstances.
I can tell you what you want to know what I'm inferring.
What are you inferring?
I'm inferring that we're probably going to get a case like this to the Supreme Court at some point.
And you know what? I'm going to go out on a limb and assume that Justice Alito writes one of the opinions.
I think that's a good inference, Chris. All right, so that's your update. 3 cases now that have to do with K-12 selective admissions, one of which is moving forward.
But not at the Supreme Court level.
But not at the Supreme Court level. The other 2 have been denied cert at the Supreme Court level, so we haven't heard the end of this.
No, we have not. And it's also interesting. The last thing I'll say about this is like there are a ton of educational cases that are getting to the Supreme Court that the Supreme Court is declining to hear right now. And so like this is one of them, the selective admissions issues. There was also I think it was a Wisconsin case that was denied review at the exact same time as this one about a parental challenge to a school district's support policies for transgender students.
Mm-hmm.
And Alito and Thomas also dissented from the denial of cert in that case as well.
Yeah, they like to write letters to the editor, I guess.
That is a remarkably good way to describe what they're doing here. Yeah. Because it has no binding force. It's just basically like signaling, hey, Next time,
I'm not happy with this.
right. Next time, here's what you guys should think about.
Yeah.
The Alito cheat sheet.
All right. Well, that's our bell ringer for today. Let's get into the case, shall we?
You promised me more Las Vegas jokes. What do you got?
Well, what happened in Vegas in this case did not stay in Vegas.
Nice.
Yeah. All right. I mean, that one was an easy one.
This show is nothing if not grabbing low-hanging fruit. So
Fair. Okay. So today's story takes place in Las Vegas, Nevada. Nevada? I
Whichever.
think it's Nevada.
I've heard it both ways.
I've heard it both ways, but when I was in Nevada, I think I heard people from Nevada say Nevada. Okay, so this takes place in Las Vegas at a magnet school in the Clark County School District. So Clark County is Vegas. It's a magnet school in the district, and it's called the Las Vegas Academy of the Arts. All right.
And I find that really interesting because this whole thing takes place in a drama classroom.
Yes.
So that's like just really important context.
Lots of drama in this case. So the case was decided in February 2024, which feels pretty recent, but interestingly, that's about a year ago already, which is crazy.
Wow.
Yeah.
So
So
it's still ongoing. Like this didn't end the entire case.
No. So what we're going to talk about, though, is this February 2024 ruling, all right, which was a motion to dismiss, right?
It was. It's your favorite. It's a 12B6 motion to dismiss.
It's a 12B6. Yeah. So just as a reminder, when we've got these motions to dismiss, what we're doing here is we're just accepting all of the facts that came from the parent's complaint. In this case, they're the plaintiff. And so for these motions to dismiss, basically everybody is saying, yes, we agree to the parent's version of events. Okay. And so everything that we're going to talk about in this case, for the most part, is all just coming from the parent's side of the story.
Right. And the school has not had their chance to tell their side of the story just because of the procedural posture of the case.
Right. And that makes sense because the school they're asking the court to just toss this thing out. And so what they're kind of giving in return for the potential privilege of having this thing tossed out is they're saying, we think we win just...
Even if you take them at their word, we win.
We still win.
Yep, exactly.
So we'll give you that, and we hope that you rule in our favor.
Mm-hmm.
So we've got the parents' version of events, which essentially goes as follows. In March of 2022, Las Vegas Academy of the Arts drama teacher Kelly Hawes, as a part of her drama class, required her students to write a short monologue that would then be performed by a fellow student. Okay? Seems simple enough.
Yeah. And this is a high school drama class at a magnet school for the arts, right? So like that's a very specific kind of student, right? Like very specific kinds of expectations.
Yeah. You know, and you could potentially read into that as like, all right, these are high school students, you know, at an art school. So they have some sort of, you know, degree of developmental sophistication because of their age. And because of the fact that this is an art school, they are often confronting, how should we say it? I mean, provocative is not necessarily the right
like
word, but like
heavy
material, like the arts are all about sort of making sense of the world and interpreting the world, right? And the world is not
place.
Is not simple. It's not sanitary. It's like there's messiness out there, right?
Yeah.
And the arts really, like that's part of what makes the arts so important is they help us grapple with that messiness and make sense of that messiness, right?
Spoken like a true professional musician.
Thank you. I wrote something on this many years ago about the power and the potential of arts. Anyway,
I love it. No, I'm 100% on board.
So hopefully you're with us so far, listeners. So after the students wrote these monologues, one of the interesting things here is that Hawes, the teacher, reviewed, edited, and approved all of the monologues.
Which is probably good because these are high school students writing, you know, dramatic monologues.
Yeah,
so
it seems like it's an important step in the process, and I'm glad that she went through that.
Yeah, whether she could have gone further through that.
Or whether she went through them appropriately or effectively or whatever is
one of the questions of this
one
case.
of the questions here. Yeah. So she printed out the monologues after that, and she told students to pick one at random. And I guess that a couple of the stipulations that she had was you can't pick your own, and you can only pick one and put it back in the pile and pick another one once.
Okay, so you get one mulligan.
Yeah, I guess. Yeah. Not a Vegas reference, but a golf one, which, right? Isn't a mulligan a golf thing? I don't know.
Golf.
Whatever.
Yeah, we're great at sports references.
So in this class, we have one student at the heart of this case, R.E. So R.E. is a minor. She is a female student, and that is all we know. So R.E. pulls a monologue. She doesn't like it, so she draws another one. The second monologue is the key to this case, all right?
Yes.
And the complaint describes this monologue as, quote, a sexually explicit, obscene conversation about a girl coming out as a lesbian to her boyfriend, unquote. All the court says about this monologue is that it, quote, contained sexually explicit language concerning the girl's interest in her female roommate and her disinterest in having sex with a man. Okay?
Okay. And that's all the court said about it.
That's all the court said about it. And I don't know about you, Chris, but that's irritating to me.
I hate it. Like, so this monologue is at the heart of this case, right? Like, and
exactly.
all we talk about on the show is that context is everything in the law. And here we don't have the context, like the court doesn't give us the context of what's in this monologue.
Right. And the court often talks about how important context is, right? Like if you look at the Brandy Levy case, for example, I mean, the context is huge there. And the context has so many implications, right, about what kinds of student speech should we as schools get involved in restraining. And without those specific context kind of examples of what is allowable and what isn't, without those examples, it's really hard for us to make good decisions.
Yeah. And just look at the Bong Hits for Jesus case, right? Like the entire case was context.
Exactly. And so in this particular case, when the thing at the heart of this case is this monologue that the quote refers to as being sexually explicit, and one side says that's a major problem and the other side says that isn't a major problem, if we don't know what they're referring to as being sexually explicit, how are we supposed to make better decisions as educators moving forward?
Yeah. And maybe like the most generous reading of this is that we have to trust the parents right now. So like if they say that's what it is, that's what it is.
Okay.
But I don't think that's good enough for our Chalk and Gavel listeners. So
that's
Jamie, I think you tracked down the actual monologue, right?
We tracked down the actual monologue.
I think this is where our disclaimer should appear, right? Like,
yes,
this is sexually explicit. Like it does have some profanity, which we won't say because we like our clean podcast rating, but it does have some like sexually suggestive metaphors and uses some sexual language. So if you're listening to this with kids in the car or anything like that, maybe skip a forward 30, 45 seconds.
Yeah. I'm going to try to read this sort of as flat as I possibly can without...
give it some spin. I think you should go full like, I'm just...
Drama student?
Drama, yeah, obviously. No, like in my head, this is being read by Anna Kendricks. And I don't know why, but she's the actress I went with for this monologue.
See, now the listeners are going to think of, as I'm reading this, they're going to be like, he doesn't sound anything like her.
Well, and I mean, I can give you some other notes, like maybe like Emma Stone from Easy A, like maybe that vibe. Because there's some comedy in here.
You know what? Let's just do it. And
all right,
here we go. So now is the time to skip ahead.
We've played it up enough.
Yeah, now is the time to skip ahead if you are sensitive to this stuff. Okay, here we go. This is the monologue in question. I don't love you. It's not you. It's just looks down. Your dick. I don't like your dick, or any dick in that case. I cheated, Joe. We were long distance, and I'm in college, and me and this girl, my roommate, started having some drinks, and I thought it was one-time thing, but then we started going out for coffee and started sleeping in the same bed. I never thought it would get this far, but God, it was like fireworks. And I can't do this. And made me realize...
You're doing great.
Thanks. And made me realize with you, it was always like a pencil sharpener that keeps getting jammed. I've tried to look at it from all different perspectives, but the truth is, I'm an effing lesbian. I'll never love you or any man or any effing dick. I hope you find a nice straight girl because that's not me, and I'm tired of pretending that it is.
Bravo.
I mean, I said that with sort of disdain. I mean, maybe she was coming at it from a more sensitive
So I think there's like
perspective. I don't know.
And I don't know either. I mean, there's definitely some humor elements in there, right? Like the stage directions of looks down.
Looks down.
Like
Yeah.
that got me. I know, like, try to be a little bit more serious here. Some good metaphor in here as well,
It's like a pencil sharpener that keeps getting jammed.
right? Comparing that to fireworks.
Yeah.
I think there's room for interpretation here. Like,
But I think that's potentially part of, I don't know, but that could have potentially been part of the reason for this kind of assignment in the first place, is to help the kids in the class kind of figure out where this might have been coming from. Was, did this person have disdain for Joe, or was
or is it
she
more like defiant? Like, I am, right? Like,
yeah, I want to
proud,
shout it from the
right?
rooftops.
Exactly, yeah. And I think, like, yeah, to your point about like the educational value here is these students wrote a monologue, and you've got the reading of it in your head, but then you see it performed by somebody else who like might have a completely different take on it because all they've got are the words on the page. Right. So like, I love this assignment. One of the big questions here is like, what's the educational value of this whole thing? And
that's
Jamie, I think you and I have kind of started to, right? Yeah, we've started to articulate those.
I think so. And anyway, let's keep going here. All right.
Right. But not to bury the lead, RE had to memorize this and deliver it in front of a class of her peers.
That's what she had to do. She had to memorize it and read it in front of her peers. And that's intense. So at this point, RE, like you said, believed that she had to memorize this and perform it because she had already used her mulligan, as you put it. So she felt compelled, that like she didn't have a choice, right? Mm-hmm. That was essentially RE's take, is I have to do this. I've used up my mulligan. This is the assignment. I've got to do it. She also said that she liked and respected her teacher and didn't want to disappoint her. Okay. Which is an interesting thing. That's going to come into play a little later on.
Right. That's an interesting wrinkle here, because then there's not just kind of this pressure about like your grade, but there's also like the social pressure of not disappointing this kind of respected teacher.
Right. So she performed the monologue, and one of the interesting things that the complaint alleges is that she performed the monologue not understanding some of the sexually explicit content. And that was a little weird to me.
I have questions about that.
I do too, because, reading that monologue, it doesn't...
It's not subtle.
It's not subtle, no. And it's not, I don't know. Like everybody's got a different upbringing.
It's true. And they're also high schoolers. Like,
yeah, and high schoolers are in very different places, many of them, in terms of what they know and understand. But that's pretty...
Right. Which raises a question for me about this whole complaint, is like, how much is this the student's perspective and how much of this is the parent's perspective kind of being imposed on the student, right?
Yeah.
And we'll talk about that kind of as we go as well.
Okay. So at this point, things kind of go off the rails, right? Because that's generally what happens in most of the cases we talk about. At some point,
there's a turn, right?
Something turns, right?
And then there's more.
So nothing at all happens for a month. But after a month or so, RE's mom, Kendra, I am assuming I'm pronouncing that okay, finds the written monologue and asks her daughter about it. So her daughter did not mention this at all. It looks like mom stumbled upon the writing at home somewhere. Like, RE
which must
brought
have
it
been
home.
Kind of confusing.
Yeah. Like maybe you thought that your daughter had written this. I have no idea.
Right. Yeah.
So she asked RE about it. RE tells her what happened. And this is probably my favorite line of the court opinion. But the court then says that when Kendra learned that the monologue was a school assignment RE was required to perform, she hightailed it to her daughter's school and spoke to the assistant principal.
Yeah.
That's funny.
She hightailed it.
She hightailed it. That's written in the court opinion. Yeah. So apparently the assistant principal agreed that the monologue was inappropriate and told Kendra that he wanted to meet with RE to, quote, let her know that she could tell teachers no, unquote, if she felt uncomfortable with an assignment. Now, that's interesting to me.
Oh, yeah?
Because, the courts have kind of repeatedly ruled that kids do not have this sort of blanket ability to pick and choose what they will learn and not learn.
Right. And same with parents, too, right? Like
Same
when
with
parents
parents.
object to that stuff.
Right.
But
there are policies and procedures in place to object to curricula, and the courts have kind of repeatedly said that you really don't have the right to pick and choose, something that you don't agree with or something that makes you uncomfortable. Yet here the AP is basically saying you have the ability to say no.
Right. I was going to say it's a difference between like the students don't have the right versus the school has the ability to, right? Because like just because students can't force the school to do something doesn't mean the school can't give them that on its own.
Oh, 100%.
Right. So like if the school has a policy like, or a practice of even saying like, hey, if there's an issue here, let us know and,
And
we'll
we'll talk
work with
about
you.
it. Yeah.
Right. Like,
Yeah.
there's nothing saying the
that's
school
not what he
can't
said.
do that.
That's not what he said, right? He said, listen, I just want to let you know, you can tell teachers no, which I think is a little misleading, especially
Well,
to
and it
kids.
also ignores the power dynamics in the classroom.
Exactly.
And
Anyway,
the
let's
social
keep going.
dynamic of a respected teacher assigning this.
Yeah. Totally. All right. Well, let's keep going. So Kendra agreed to that meeting between the AP and her daughter, but asked that a female administrator also be present. And that kind of, that doesn't sit the wrong way with me. Like this is sensitive material and a female student talking about sensitive material, sexually explicit material. And that doesn't really bother me. So they brought in a female administrator. They had a very productive meeting and everybody went home happy, right?
Did we read different cases?
No, because that's not what happened. The AP
Right.
ended up meeting with RE alone, and the complaint alleges that RE told her parents that she was scared and upset that the AP called her into his office alone.
Right. And I think this is kind of the
This
first
is where the bad look
instance.
starts.
Right. Like, because there's two issues here, right? There's what happened, and then there's what the school did about it.
Exactly. And this is where the
That's true in so many cases, right?
Absolutely. And it's not necessarily a question of the school making horrible decisions every step of the way in these kinds of cases, even though sometimes that happens, but it's often a potentially bad decision or a bad move, or it's a questionable move that happens over and over again, or that creates a bad look or whatever, but it's never resolved properly. Like it's almost like every time they make a decision, every time there's a decision point, they kind of pile on, right, the questionable moves.
It's not even like what they do, it's how they do it. Right?
Yeah.
Like, do you have open communication? Do you help this parent feel heard? Do you like all of these different things that like could end this now without it snowballing? And I think that like it snowballs. It just keeps rolling down the hill. And every time there's a new bump in the road, it just picks up more steam. It gets bigger and it just keeps going until, we get to my side of the equation and somebody files a lawsuit.
Exactly. So Kendra at this point was not done hightailing it to speak to school administrators.
Right. Because it feels like she didn't get listened to the first time. So.
Right. I asked you to meet with I said it was fine to meet with my daughter. I only asked you to have somebody else in the room. You didn't do that. And my kid felt scared and upset about that. So over the next few weeks, she met with the AP. She met with the teacher. The teacher defended the assignment, saying that RE could have said no or addressed it with her if she was uncomfortable. Well, we have no idea how that was communicated or even if that was communicated to the students. Right.
But that's something that I think is really interesting about this whole case is the student gets the monologue, memorizes it, delivers it, and apparently like the teacher has no idea about this being an issue, right? Like, and it doesn't become an issue until a month later when the mom finds it on her own. Right. So like that I'm sitting here asking this question, like, recognizing that this complaint is very much from the parent's perspective, like how much of this is an actual issue for the student and how much of this is an issue for the parent.
Exactly.
And that
we don't know.
We have no idea, right? Because we have to kind of accept this version of the story. And like, the student hasn't gotten on the stand and testified or been sworn in. But I think that that's really important though, because it tells us what the drama teacher knew about what was going on when it was going on, right? Like, if there's no indication that the student here, RE, is like uncomfortable or is, not fully engaged in this activity, then like there's nothing to really fault the teacher for, right? But the flip side of that, though, is it's not the student's responsibility to say, hey, I don't like this, right? Like, I don't want to put that on the student, which it sounds like that's one of mom's critiques of the school, is they kind of put this on the student to say like, oh, well, your student should have said, no, thank you. And I don't, that makes me feel pretty uncomfortable.
Well, yeah, because, and we've talked about this in other cases, is that there's always these power dynamics, right, between adults and children in this coercive potential relationship. And so even a teacher saying, you've got the ability to do X, Y, or Z might not be enough for the student to feel comfortable doing X, Y, or Z, right?
Right. Especially if it's someone like, the drama teacher. If this, it's a school for the arts, so they might have more than one drama teacher. But like, if that's your thing and you don't want to upset that person because you don't want to like get passed over for good roles or whatever it might be, like, that has some social coercive power as well.
Right. And like you said, we have no idea how much of this was a bother to the student versus how much of it was a bother to the parent. We don't know. It's probably somewhere in the middle because everything is generally somewhere in the middle.
Right. I want to know how RE like delivered the monologue. Like, what kind of dramatic choices did she make? Like, how into it did she get? Like, because I think that really kind of shows, like, if she went full out and like, Meryl Streeped it, this is a very different case.
I absolutely think so. I mean, because again, it's not like she was forced to read this monologue cold and deliver the monologue sort of without having an opportunity to read it, absorb it, think about it. I think the whole point of the activity by asking them to memorize it and perform it was read this thing, internalize it, try to get into the head of this character, right? Try to, there was a lot of opportunity here for RE to wrestle with this material. And I have a feeling that if she was incredibly uncomfortable with this, it might have that discomfort might have come across in the delivery.
Or she's an incredible actor.
Or she's a great actress, right? So anyway, let's kind of
Or both. It could be both.
It could be both. These are all very important points to kind of think about. But we
don't have the information for it yet.
We don't have the information, and we want to keep this episode under 7 hours. Let's see what happens next. All right? So mom's not happy. She's speaking to a lot of different people. She met with the AP. She met with the teacher. She met with an associate superintendent who also expressed that the monologue was inappropriate and that no administrator should have made RE feel like she had any responsibility for having done the assignment, and promised to speak to the school's principal to investigate and ensure that it didn't happen again.
Which, like, that feels like a good response, right?
It sounds like a solid response.
Right, like, hey, it's not your daughter's fault. Like, yes, that's inappropriate. I'm going to look into it. I'll make sure something.
Right.
I'll let you know about corrective actions.
Right. And Kendra, at that point, asked the associate superintendent, and I completely understand this given the fact that she had kind of asked this before. Kendra asked the associate superintendent to ensure that no school administrators or teachers at the school met or spoke with RE about the situation unless she was also present. And while that's a big ask, I also, given how everything has unfolded so far, where she asked the AP to meet with RE with somebody else there and he didn't do it, I can understand this ask.
I can understand it too. I'd struggle with it though, because schools have to be able to do their work, right? And just because a parent wants it to be done differently doesn't mean it's done wrong or inappropriately. And so we can't, it's not possible. It's not even feasible to let kind of parents make these sort of dictations to schools.
No, but I agree in principle, but my opinion in this particular case is the situation has unfolded the way it has. And one of my jobs as an administrator is to de-escalate the situation and try to come to some sort of mutually agreeable resolve, right?
Yeah.
And so if I need to eat a little bit of crow to do that, I'm going to do that. If I'm going to need to sort of concede to the parent a little bit and say, you know what, why don't we all get together,
Right.
you know,
Let's
and
have some restorative conversations.
and
Yeah.
sort this out.
Yeah.
Then there's a good possibility that either that could be the complete end of it, or at least at that point the parent feels heard and valued. Okay, they granted my request, even though we didn't have to grant your request.
We're doing it because we value the relationship.
We're doing it because we
Yeah.
value the relationship. We're doing this to resolve the situation.
Yeah. And I think that like that is the crux of so many of these situations. Like there's the situation and then there's how you address the concerns.
Exactly.
And if you make people feel valued, if you make them feel heard, if you
Yeah.
basically respect them as equals, as equal participants, then like, yeah, I think that goes a long way. So yeah, Jamie, I see your point. Like they weren't required to do what the parent asked, but maybe it was good. Let's call it human relations, or PR makes it feel way too sanitized, but like it was good for a school leader to maybe acquiesce to those.
Yeah. I think so.
Okay.
Now, I have no idea how that request was received by the associate superintendent, but whatever the case, Kendra wasn't done. So she also tried to file a police report.
That's an escalation.
That is definitely an escalation. So she tried to file a police report. The officer that she filed the report with was described as, quote, being dismissive of her concerns.
Right. Which sounds like the challenge that she's been having with the school district as well.
Yeah. I mean, at least
Right.
that's up until this point, it seems like her perception of events is that everybody is blowing me off, or
Right.
everybody is not listening to my concerns. Everybody is, ignoring my requests, whatever.
Which, like, to get to the point of filing a police report, because that, like, that has criminal penalties to it.
Exactly.
Right? Like, that's not insignificant. And I think she's alleging that, like, exposing minors to sexually explicit material violated these criminal laws, right? Like, and
this is where things get a little contradictory for me, because, and we're going to see it in a minute, by going to the police, like you said, they're alleging that criminal activity is taking place. In a moment, you're also going to hear something that the parent said at a school board meeting, where she basically says, look, my kid likes the teacher. I'm not trying to get her fired here.
Right.
And so that sort of...
Which her goal isn't to, like, have punitive discipline against this teacher.
Why'd she go to the police?
Then she just wants to be heard, and she wants someone to acknowledge the significance of this and to, like, ensure it doesn't happen again.
Right. But then
Right,
why'd
like-
she go to the police?
It's a great way to get someone to listen to you. I guess, like,
maybe
that's kind
what
of
it
like-
was, but we don't know if that's what it was, or like if she went to the police because nobody's listening, or if she went to the police because she thought that there was some sort of criminal activity here. We don't know.
Yeah.
So, of course, that's not the end of it. Just wait. There's more.
Always.
So Kendra went to a school board meeting and decided to speak during the public comment period of the school board meeting. So usually at the end of these meetings, there's time set aside for any member of the public to be able to get up and raise a concern or talk about a particular issue or whatever, right? The public comment period. So during that public comment period, she decided to read the monologue out loud. She was stopped by one of the board members because it contained profane language. Kendra took issue with that and basically said something to the effect of, well, if my kid had to read this in class and you're not going to let me read that here.
Right. Like that is like, I don't know if it's ironic, but like that's an issue, right? Like if you can't do this monologue in a public meeting, then why was it in a high school classroom?
Right.
And
now,
like we also bleeped some of it out too. So like, it's also ironic that we're talking about the assignment and also, we still censored it as well.
Yeah, exactly. And so it kind of gets interesting here because she was stopped and it looks like the board members are trying to wrestle with that particular question that was raised, which was, okay, she's reading something that sort of happened in the school, but our initial reaction to that is that's profane and that's not allowed in these school board meetings. So we need to kind of reconcile how to deal with this.
Mm-hmm.
And things kind of got interesting there for a second where the board was trying to figure this out. She was trying to make her case. They turned her mic off.
But they let her finish her.
But then they let her
prepared remarks.
They
with
turned
her 2
it
minutes,
back
right?
on. Yeah, they turned it back on. They let her finish her remarks. She didn't finish reading the monologue, but she basically was just saying, I don't find this appropriate. I think that it violates the law. And she read the law that it violates. And, like I said before, she also said, listen, my kid likes the teacher. She would be devastated if this resulted in the teacher getting fired. I just want to be heard, and I want this looked into so that this doesn't happen again, is essentially what it boiled down to. So we're going to play that board meeting because that was a public board meeting, so that that information is available to the public. So we're going to play it for you now just so that you can hear with your own ears exactly how all of this went down.
I'm going to read you an assignment given to my 15-year-old daughter at a local high school. This will be horrifying for me to read to you, but that will give you perspective on how she must have felt when her teacher required her to memorize this and to act it out in front of her entire class. I don't love you. It's not you. It's just, I don't like your dick, or any dick in that case. I cheated, Joe.
I'm sorry.
This is propaganda.
Forgive me. Excuse me. I don't. Thank you so much for your. Thank you for your comment. Forgive me. We're not using profanity. Are you?
Okay.
What?
That's relevant.
Okay.
Yes. The teacher
This
required my daughter to memorize this and read this pornographic material.
Excuse me. Please don't engage with the audience.
Okay. Sorry,
So
it's my
please
first time
continue your
here.
public comment. Your time is. You've got 1 minute and 19 seconds. I ask you simply. This is a public meeting. I ask for decorum, and I'm asking Dr. Jara. Thank you so much, Dr. Jara.
If you don't want me to read it to you, what was that like for my 15-year-old daughter to have to memorize pornographic material and memorize it and portray?
Madam President, members of the board, staff's on this. We can have the region superintendent speak to her.
Thank you so
We
much,
are on
Dr.
it.
Jara. It seems like you may have some concerns, and while we're not allowed to engage back and forth in a dialogue, we would absolutely like to make sure that your concerns are addressed.
Material, just finish what I was going to say.
Please.
My daughter was forced to engage in the portrayal of this blank activity by her teacher. We have pornography laws regarding minors in this state, and many of those were violated because of this assignment. I don't have time to name all of the laws that were broken that day, but one example, NRS 200-710. It states, it is a crime when a person knowingly uses, encourages, entices, or permits a minor to be the subject of a sexual portrayal in a performance. In one of my meetings with school administration, they blamed my daughter for not saying no to the assignment. They blamed my daughter, who is the victim. Teachers are in a position of power. Educators must understand the laws about sexual abuse, and that is where I am hoping you will help. If I had not reached out to a local parent advocacy group, Power to Parent, for help, I may never have gotten a meeting with the regional superintendent. And truly feel this incident would have been brushed under the rug. However, this meeting went really well, and I now have some hope that corrective action will happen. My daughter thinks the world of the teacher, and has raved about her, so it's not that I want her to get fired. That would devastate my daughter. I don't want to make a horrible situation worse. But she is struggling with this. I hope that you will reach out to me to let me know how you can help. Thank you.
Thank you, Ms. Evans, for taking time to come to the board meeting. Ms. Batista.
Okay, that was the portion of the school board meeting.
Right.
That was
and
sort
I'm
of
really impressed with how, like, the parents' demeanor there.
Yeah, everybody was very calm.
Yeah, like, I think everyone kind of handled it pretty well. I don't know if I'm the school board if I try to enforce the no profanity rule just because it's a really bad look.
It's a very bad look. Yeah, she definitely said, this is something that my kid was forced to read, and you're not even allowing me in a room
Right.
full of adults
Yeah.
to
No,
read.
like, it's a strong argument. I'm not going to lie.
And listen, there's probably procedural stuff here about, who speaks and when, and, and all of that stuff.
And the no back and forth
and the
or whatever.
no back
Yeah.
and forth, but most, the average person probably is not very familiar with Robert's Rules of Order and all of these things that kind of govern how these meetings play out. And
I
so,
object.
so maybe, maybe the better look would have been for the board to say, all right, we're going to give you your full time back, say whatever you'd like. And then at least that doesn't come across as the board trying to silence somebody.
Right.
Because
this got picked up by social media.
Oh, yeah, that. Yeah. Because I guess maybe that Libs of TikTok account found the video and posted it, and it got, a couple million views or something. So it got out there.
Right. With the idea of being like, this student was forced to say this in class, but the mom can't say it at a school board meeting.
Yeah, exactly.
Yeah.
And even though the reason why she was stopped from saying it could have been more of a rules of order kind of thing that they were trying to wrestle with in the moment.
And we also don't know the context, right? Like, it could be just a running thing where, like, these school board meetings have gotten a little rowdy and they're just trying to enforce rules of decorum.
Right.
Which they have the right to do.
Yeah, absolutely. We have no idea, but that's sort of the view that got out there. Like I said before, if the school board had just kind of taken a little bit more of
deferential.
If the school had taken a little bit more of a deferential approach or whatever, it might not have gained that kind of traction, and maybe that message might not have gotten out there, so so to speak.
And it could have also de-escalated the situation and made mom feel a little bit more listened to.
Yeah, exactly. So, of course, that's not the end of it. The last little piece of this is the day after that school board meeting, apparently the principal pulled R.E. out of class and met with her alone, again, to discuss the situation in, quote, this is so interesting, in an alley behind one of the school buildings.
Yeah, and that's straight from the parents' complaint.
Yeah.
But
again, the school district did not choose to argue about any of these facts.
Well, so at this stage, like, it's just, the school district isn't saying yes or no. They're basically just saying, court, even if you accept everything, it doesn't matter.
Yeah.
So, like, the school has no, I mean, they probably honestly denied this when they responded it, but like the court doesn't care.
But what's interesting to me, though, is that the school knows that that's what they're asking the court to do. They're asking the court to say, you know what, it doesn't matter, the school's fine. But what's interesting to me is, how can you look at all of these events and say, yeah, this, at the very least, this is a lot of bad looks on the school, right? And even though legally, being a bad look is not necessarily a legal precedent.
I was going to say that,
right?
There's no cause of action for bad look.
No. But like, I don't know. For me as a school, I would be concerned about that.
Well, there's a difference between a school leader's concern and an attorney's concern.
Yeah.
Right? And like, you pass this to an attorney, and the attorney's like, yeah,
we could
you
win
can say you don't
yeah.
like it, but where's the legal cause of action here?
Yeah.
Right?
Yeah, exactly.
And so, all of that to say, like, the alley behind one of the school buildings, like, that just feels like a zealous advocate who's just like trying to paint the school in as bad of a picture as possible.
Right.
Because, like, this is a school in Las Vegas, which means it probably has different buildings. Like, the buildings, there's probably no, like, connected hallways. They're probably just separate buildings.
Yeah,
so, like,
maybe.
an alley behind one of the school buildings is probably just like, hey, I pulled this kid out of class and we talked next to a school building.
Maybe. One of the other interesting things here is that apparently in that conversation, the principal told her that there was a shortage of teachers and that he was hoping to hire teachers with, quote, proper training soon, unquote.
Yeah.
And
there's no way a principal said that,
what?
right?
Like, seriously?
To a high school student? Come on.
Like, really sorry this happened, but it's
Let me
because
admit that I hired
I hired
people.
somebody who was incompetent, and I'm really hoping to change that, so please forgive me.
Right. But, if he did say something like that, that's a problem.
That's a problem.
Yeah.
So at that point, he took R.E. to the drama teacher's classroom, and he left her alone with the drama teacher. Hawes, who was the drama teacher, remember, in that moment told R.E. that she was sorry that R.E. felt the assignment was inappropriate. At that point, R.E. began to cry, and then, and this is a direct quote from the complaint, Hawes, quote, initiated contact with R.E. without permission, unquote, which was allegedly grabbing her and holding her. And that's all it says, all right?
Right.
So it sounds to me like what happened is the principal dropped her off in the classroom to sort of, kind of work this out with the drama teacher.
Yeah. Hey, fix this.
Yeah. The drama teacher apologized, even though, again, this is just the parents' version of events, that the quote was, "I'm sorry that you felt the assignment was inappropriate," which was, sort of putting
Shifting
that
responsibility. Yeah.
responsibility. We don't know if that's how the drama teacher phrased it. We don't know. It's just the parents' version, right?
Right. We also don't know what this grabbing and holding thing is.
Right.
'Cause
Like
my take is
she was giving her a hug.
a hug, right? Or like a hand on the shoulder, like, hey, it's okay. Like, I get it.
Or
I'm so sorry you're experiencing this. Like
what I want to believe is that I want to take the parent and the student at their word that this teacher was a teacher that RE liked and respected. Okay. So I want to sort of establish, I would like to believe that that is our baseline. And I would like to believe that this was a moment where the teacher was trying to apologize to the student. The student was upset.
or just overwhelmed with the whole thing. Like her mom was talking in front of the Clark County school board.
Yeah.
Like this school board district is one of the biggest school districts in the nation.
Right. And we have no idea if RE has been sort of shut out of the conversation by her parents. And maybe RE doesn't want this publicity. Maybe they were not as upset by this as the parents were. We don't know.
Right. Yeah. We have no context. Like, yeah, it could just be like she's totally overwhelmed with how the situation had gotten.
Which
is
makes
crying
perfect
because
sense.
of the situation and not because of like her
Fear.
experience with this monologue, right? Like,
right. Or she's not crying necessarily out of fear of this teacher because of how this thing has gone so out of control
it could be
or whatever.
Yeah, that could be a safe place for her, right? Where she's just like able to express those emotions that she's feeling.
Right. Yeah. We have no idea, but I would like to
the complaint
believe...
makes it out like this teacher is like grabbing her and shaking her for crying. Like,
yeah, no. And I don't,
which there's a lot of things in this complaint where I'm like, raising my eyebrow because the whole like alley behind the school building.
Yeah, no, I
dropped
know.
her off alone. It's very inflammatory, right? And it's a lawsuit, right? So like that's just kind of what you do, but I don't think it's very successful.
It bothers me on a number of different levels. I mean, it bothers me, if the school did indeed handle a variety of these circumstances the way that it alleges. I have a problem with that.
Right, especially because this meeting violates the request from the parent to like not have anybody talk with my daughter about this thing without me. Yeah.
I mean, she said that on multiple occasions, yet still on multiple occasions, different members of the school did exactly that. So, I mean, I've got lots of problems here. This gives us a ton of stuff to think about with really important practical implications for teachers and schools. But now is a very good time, probably 30 minutes ago was a good time, to find out how the courts played with this.
Yeah, because the courts aren't coming at it from the same perspective as a school leader, right? They're just looking at...
They're looking at the law.
What's the law say?
It's all yours. The floor is yours, Chris.
Yeah. So we've talked about how, mom might be feeling about this whole thing, but, apparently things have not been resolved to the parents' or RE's satisfaction because they do what everybody does in Chalk and Gavel, and they filed a lawsuit. And they filed a lawsuit against everybody.
Well, that's normal, right?
This is, and we actually just talked about like this complaint and some of the issues I have with it. This is a spaghetti lawsuit, right? Like they are throwing everything at the law against everyone and they're seeing what sticks. Yeah. Spoiler alert, not everything sticks. I would actually say most stuff doesn't stick.
Yeah.
So here's what we've got. We've got a claim for a First Amendment violation for refusing to allow mom to speak and to read the monologue at the school board meeting. So mom is alleging that her First Amendment rights were violated when the school basically silenced her or cut her off.
Okay.
There's also a claim that the school impermissibly compelled RE's speech by requiring her to perform the monologue. That's the one I think is the most interesting and the most significant.
Yeah.
We've also got claims for negligent supervision and training, as well as negligence against the school and the teacher. We've got some other tort claims for intentional and negligent infliction of emotional distress, which I don't think is a tort we've talked about yet.
Interesting.
But it's saying like somebody acted recklessly or wantonly towards another person and it caused emotional distress.
Okay.
And then last but not least, we also have a claim for, this one makes me so angry. We have a claim for assault and battery.
Oh, for the hug.
For the hug.
Yeah.
Yeah. So that's based on the allegations that the teacher grabbed and held RE during a conversation about the monologue.
Okay.
So there's a lot in this complaint.
Yeah.
And we've already alluded to it. The school got the complaint and said, no, thank you.
Oh, 12B6.
Exactly.
Yeah.
Yeah. Because this is where they
Toss
file
it out,
their
man.
they file their 12B6 motion to dismiss for failure to state a claim.
Great.
We've talked about this. Like, the court assumes at this point everything the parent says is true, and the parent just has to meet the very low bar of alleging a plausible claim for relief. So it just has to be like, you have to give us enough information to make it plausible that the school broke the law or violated your rights.
Yeah. And if the claim passes that test, it can go on.
It goes on to discovery, do depositions, you do document review.
So basically, like you said before, not everything sticks in this case. So some of the things pass that test and other things do not.
Right.
Okay.
Yeah. And, maybe that's the right choice. Maybe it's not. But let's not get ahead of ourselves.
Okay.
So first up is the claim about silencing mom at the school board meeting.
Okay.
So mom is claiming that the school violated her First Amendment rights to free speech when it muted her mic and prevented her from speaking during the public comment period.
Okay.
And this is kind of a tricky claim because the First Amendment is complicated, right? Like, it's complicated in schools. It's also complicated outside of schools, and it's complicated when you put them both together.
Mm-hmm.
And so typically in these cases, one of the most significant facts is, where does the speech take place? If it takes place in what's called a public forum, then the school has very limited authority to basically censor that speech. If it happens in a non-public forum, then the school has pretty strong authority to limit that speech, as long as it doesn't do so in a viewpoint discriminatory way. So basically, like, you can't punish people who disagree with you if you don't punish people who agree with you.
So this is clearly a public forum.
This is what's called a limited public forum.
Ooh.
Just because,
of course,
it's not...
why should it be easy?
Right. So public forum typically are things like sidewalks, like public sidewalks or public parks. Like, and this is almost a direct quote, they are the spaces that have been held time immemorial for public debate and discourse.
Okay.
Right.
Okay.
But a limited public forum is a forum that the government creates for a specific purpose, like a school board meeting, right? So they've created this forum where people can come and talk, but because it's a limited forum, the government can limit comments to things that are basically relevant to that forum.
Okay.
So you can't get up at a school board meeting and start talking about taxes. Well, you probably could talk about property taxes.
Yeah,
but
I totally get what you're saying. Yeah.
You're not going to get up there and talk about the Pentagon's defense budget.
Right.
So within a limited public forum, the school can impose reasonable restrictions as long as they don't engage in viewpoint discrimination. So at the school board meetings, the school imposed content restrictions that limited discussion to things that are relevant for the school. And they can also put in kind of like reasonable time, place, and manner restrictions, like say, hey,
you only have a couple of minutes to speak.
You only have a couple of minutes. It's not a dialogue. And please don't use profanity.
Okay. And so all of that was in the Clark County's school board policies?
Board policies, yep.
Okay.
Yeah, so there's a board policy that essentially says, don't use profanity.
Right. Fair enough.
And so the court looks at all of this. They've actually watched the video that we played for the audience, and the court says, look, no one actually prevented you from speaking. Like, you still got to say your piece.
They just asked you to not be profane.
They just asked you not to use profanity pursuant to school board policy.
Right.
Right. And that profanity policy is not really being challenged here. Like, that's fine.
It's just more of the, like we discussed before, it's more of the look here. It's like, all right, so the board didn't do anything wrong because they were just enforcing their policy. But the interesting issue here is that something that violates board policy was being mandated by the school. And that's sort of the look that's
gets
bad.
Into a different claim.
Exactly.
Right.
But as far as this one, First Amendment claim.
No one silenced you. You could still got the chance to say your piece, and they only told you to do it in a certain way, which they could have done because of given the nature of the format. All of that to say, this claim gets dismissed.
Yeah.
But speaking of complicated First Amendment law, let's talk about Ari's claim that requiring her to recite the monologue violated her First Amendment rights against compelled speech.
This is fascinating to me.
It is, because this is a school assignment, right? Like,
Exactly.
the implications here are crazy.
Huge.
Yeah. Like, it could be a constitutional right not to do schoolwork,
Right.
right? Depending
Yeah,
on how you
exactly.
phrase this.
Exactly.
Right? Yeah.
Yeah.
Which is really interesting because typically when we're challenging or when we see challenges to curricular decisions or to like schoolwork that students have to do, it comes from the parents.
Mm-hmm.
And the parents are arguing that it violates their parental rights. And courts have been really reluctant to recognize those parental rights unless the school is doing like really problematic things about like indoctrinating or
Right.
compelling belief
Right.
or things like that we've talked about in other episodes, right?
Right.
But here, the student is saying, no, I've got a First Amendment right not to be forced to say stuff I don't agree with.
Okay. So what the court say?
So yeah, so the first question that the court has to answer is, what standard should we apply?
Okay.
Right? Like, then
Yep.
that's usually the first question we have to answer in a lot of these cases. But we've talked about a number of different First Amendment standards that courts use to address student speech.
Mm-hmm.
So depending on the content of the speech or what, what's kind of happening. So we've got kind of three broad categories, or the court buckets these into three broad categories.
Yep.
First, there's inappropriate speech that is
Yeah.
regulated by Bethel versus Frazier and Morse v. Frederick, the Bong Hits for Jesus case.
Yeah. So interestingly, the Bethel versus Frazier case was another one of those cases where the speech itself, the actual words, were the heart of the case, but
and weren't in the court
they
opinion.
weren't in the court opinion.
I know. But
Yeah.
they were in dissent because the dissent had that beautiful line of like, are we talking about the same thing here, guys?
Yeah. One day we're going to cover the Bethel
We
versus
will, because
Frazier
it's
case.
so good.
It was just about, a student who gave a lewd and profane speech at a school
Lewd
assembly.
and indecent.
Lewd
is the
and
description.
indecent.
Yeah.
Yeah, at a school
right.
assembly or something like that, right? So,
Yeah. And that's one of the categories is essentially like schools have authority to regulate lewd and indecent speech or speech that reasonably promotes illegal drug use.
Yeah, which
So
is
like if it's inappropriate speech,
Yeah.
schools have a little bit more authority to regulate it.
Yeah. And then Morse versus Frederick was the case we've talked about before, which is promoting
Yeah.
illegal drug use.
Our 1 year anniversary case.
There you go.
Yeah. So that's one category.
Okay.
Another category is speech that is school sponsored.
The Hazelwood.
Hazelwood versus
standard.
Colmeyer.
Yeah.
Right.
School
Yeah.
newspaper case. Yeah.
Yeah. So that was a school newspaper case where the students wrote these articles. The principal pulled the articles out of the newspaper because he objected to them for educational reasons. And the court ultimately sided with the school and said that school-sponsored speech activities, schools have more authority to regulate those.
Yeah. Yeah.
Right?
Yeah.
And so that's our second bucket. And our third bucket is Tinker. We've talked a lot about Tinker.
Yeah. The disruption
But that's
standard.
the
Yeah.
substantial material and substantial disruption or invasion of the rights of others. Remember the BB case.
Yeah. 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 Yeah.
And so that's kind of like everything else. And so which of these buckets should this speech fall into? It seems lewd and indecent, right? Like it's sexually
very much.
explicit.
Like to me, it seems like that the Bethel standard is probably the clear winner here.
But
But I'm wrong.
yes,
Okay.
this time. I know
Oh.
it doesn't happen often.
It happens so much more than yeah.
No, so the court says, yeah, you might think it should be under Bethel, but this case is different because it's not pure student speech. This is part of a school-sponsored activity. So because this is part of a school-sponsored activity, because it was a school assignment, then it falls under the Colmeyer case, the Hazelwood versus Colmeyer
Okay.
case.
Okay. I see it.
And this is actually like a novel question that not a lot of courts have had to deal with is what standard do you apply to students' curricular speech?
Right.
So like,
do you apply the Bethel standard to Hazelwood? Right.
or is there a Bethel standard within Hazelwood?
Within Hazelwood. Right.
Right.
Yeah.
And there very well could be because the Hazelwood standard essentially asks whether or not the school's actions are reasonably related to a legitimate pedagogical purpose.
Okay, so then if they're going to employ that standard, then that's the question we're asking in this particular case is, did this assignment fall into the legitimate pedagogical purpose category?
Exactly.
Right.
Right. Yeah. And, to your point about like, is there a Bethel versus Frazier inside of a Hazelwood? Which that sentence makes no sense, but it could be a legitimate pedagogical interest to like curtail profanity.
Yeah.
But here, they didn't curtail profanity. They required profanity. That is a very different thing.
Well, and this kind of stuff comes up so often in schools and, in literature classes and, reading Greek mythology and, all kinds of stuff. There's
Right.
a lot of sexually explicit material.
Yeah, or inappropriate language,
Or
right?
inappropriate language, that kind of, we've had discussion, maybe not on this show yet, but there are discussions out there about racist language in some very,
Huck Finn.
in Huck Finn and other big literary.
Right. But there's also sexually explicit stuff too, like
Sure.
Romeo and Juliet, right? Like
Yeah.
classic example.
Yeah.
Yeah, like, and figuring out like, are we going to recognize a right of students to not have to engage with that curriculum?
Yeah.
Yeah. So like all that to say, like, the Hazelwood standard is fairly deferential to school authority, right? You just have to like, it's a means ends
Yeah.
test. Are the ends legitimate? Do you have a legitimate educational reason for doing what you're doing? And then the means that you're doing it, like, are those reasonably related to what you're trying to accomplish? So there's not like, you just need a little bit of overlap there between what you're trying to do and how you're doing it.
Okay.
Here, the court, because of where we're at, is kind of bound by what the parents say. And so the court is looking at this question of like, is there a legitimate pedagogical interest here?
Okay.
If there is, then the school is probably going to win. If there's not, then this thing's going to move forward because then it's a potential constitutional violation.
Okay. What happened? What'd they say?
The court said that it's possible here that there's no legitimate pedagogical interest, or more precisely, the parents have sufficiently alleged that there's no legitimate pedagogical interest for the assignment.
Well, we know that the parents alleged that, right?
But they plausibly alleged
Oh,
that.
so they didn't directly say there's no
Basically, the parents gave the court enough
to say
that
that's
a
plausible.
court could look at this and said, yeah, the school violated your rights.
Okay.
The court doesn't really get the school's perspective, right? Like the school hasn't had a chance to say, like,
Correct.
here's all of the ways
Right.
that this activity is educational.
Right.
Right? Like all they've got is what the parents have given them. And the parents say that, there's district policy that, it might not be directly on point, but it forbids staff from using profanity in the classroom.
Mm-hmm.
There's a policy in the student handbook that forbids students from sharing content that is profane and or obscene in nature.
Okay. So
we've got
that's
these
a little
policies,
bit of an uh-oh.
Right. So we've got these policies that don't seem to be followed. And,
Yeah.
Jamie, to our conversation earlier about Bethel, like this wasn't forbidding.
This was compelling.
This was compelling that, which would seem to undermine the school's interest there, right? Like, because if the school interest has an interest in curtailing lewd and indecent speech, it probably doesn't make sense that it's reasonable for them to promote it.
Yeah.
Right. And so the court looks at all of this and says, at this point, I've got enough that it's plausible that there's not a legitimate pedagogical interest.
Okay. So that claim moves forward.
That claim moves forward. And I struggle with that conclusion because, as we talked about at the beginning of the episode or 3 hours ago, there are educational values here, right? Like we talked about how educational this kind of activity could be. And that, I think, also raises a concern that I have with the standard itself. The standard is just asking, does this further a legitimate educational goal in a reasonable way? It doesn't look at countervailing interests, right? Like it's just a did you pass go standard. It's not a did you pass go, but are there these other concerns that we need to be worried about like learning the wrong lesson?
Yeah. Yeah.
The standard doesn't have that in mind. Maybe it can come in, and this is actually how I think courts handle this or should handle this, is maybe it comes in when you're talking about like, is it reasonably related? Because, something that substantially undermines your other educational missions is probably not reasonably related to your educational mission, right? So maybe there's a way to kind of work it into the standard that way.
Interesting.
But, it is really interesting that there's a potential here for a student to use the First Amendment
to avoid an assignment.
Because they disagree with the content.
Yes. This is the implications, like you said, are huge, but there's some tough stuff to wrestle with here.
There is.
Okay.
There's a lot. Yeah. And, this will be one that I think will be really interesting to see how it plays out with discovery. Just because, like, when we hear the school side of the story, I think there's going to be a lot of things that they can say about the value of these assignments. Because, it can also be valuable to, like, allow students in drama to curse, right? Like, it makes it real. That's how they actually talk. Like, it's a dramatic interpretation of a very emotionally charged scene. So like, I think the school has a lot of opportunities to put on some really compelling arguments for why this assignment was educationally appropriate.
Okay.
I guess that's me just kind of editorializing at this point, because that's not what the court said. The court said, nope, let's let it go forward and we'll see what happens.
Okay.
But, you know, there's a couple other things here. That's really the big one, because that's kind of an unsettled question about, you know, what rights students have to kind of opt themselves out of the curriculum based on their First Amendment rights. Guess what, Jamie? It's your second favorite thing ever.
Qualified immunity.
Qualified immunity.
Yay.
Yes, the teachers get qualified immunity because the First Amendment claim is so unsettled.
Yeah, new. Yeah.
Exactly. So while that claim goes forward, it goes forward against the school district and not the teachers and the principal. And then this is usually the part of the episode where I say that the court then dismissed all of the state law claims because there was no longer a federal question. But ER's First Amendment claim is still alive. So guess what? The court has to look at these tort claims.
Okay.
So we've got 3 tort claims really quick. We've got negligence, we've got intentional or negligent infliction of emotional distress, and we've got our claim for battery.
Okay.
The court looks at the negligence claims and says none of this was foreseeable enough, and there was no notice to the teacher that RE was experiencing this in any negative way. So like, there's nothing egregious here. That claim is not going to get you anywhere. We're going to dismiss that one.
Okay.
They look at the intentional or negligent infliction of emotional distress claim.
Same thing, right? Like that seems like it would be the same thing.
Right. It's exactly the same thing where like, in order to state a claim for emotional distress, you have to prove
that they knew that there was going to be emotional distress as a result
that they
of the
intended
action.
or were reckless towards creating emotional distress, and that their conduct was extreme and outrageous.
Oh,
and here,
yeah,
like, none of that's there. Like,
yeah,
there's no
yeah,
extreme and outrageous conduct, and there's no indication that they knew
That
or
this
intended
was-
to cause emotional distress,
Yeah,
right?
got it.
So that one's out as well.
Okay. What about the hugging?
That one inexplicably remains.
Wow.
I know. That one drives me nuts.
Wow.
Because, like, what message does that send to teachers, right? Like, hey, never touch a kid because someone will just write a complaint and sue you for battery? Like,
Right. I mean, listen, a lot of teachers are told that. Honestly,
but,
like
like,
a lot of
is
teachers
that-
are saying, don't ever.
is that the lesson that we want the law to teach?
Well, I mean, don't get me started on that. I
Right.
am a hugger myself, and
yeah.
and I am a very big supporter of how
Appropriate emotional support, right?
Yeah,
Like,
how important emotional support is in schools.
Yeah.
And you know what? Sometimes kids really need a hug, and not giving them one is, in my mind,
a disservice.
not just a disservice, but it's potentially harmful.
Yeah. Right, because they're not going to understand. Well, I'm not giving you a hug for legal reasons.
Yeah, no, especially
Right?
like especially with a 6-year-old, right?
Yeah,
Like, I mean,
right.
listen, I totally understand the challenge with all of this, especially as the kids get older, especially with gender issues. And I get all that. I get that it's hard. I get that it's complicated. I get that it's potentially very problematic. But all that I'm saying is I find the alternative to be problematic as well.
Right.
Okay? That's
And
all I'm saying.
I will say for the court, like, this was a very, very close call because there's not a lot of allegations here that this was a, like, intentional and offensive non-consensual touching, right?
Yeah.
Like, that's the claim for, that's what you have to prove for a battery. Like,
Right.
so, like, there's so little here that even, like, indicates that this was offensive, right? And, like, the court explicitly says, like, this is a close call. This barely reaches the point of plausibility, but there's just enough here to let it go through. Obviously, that's not to say that the parents or RE are going to win.
I
that
think that's
claim,
the
right?
important
Like-
point. Like, it's almost like, you know what? There's just barely enough. So why don't we see, let's get more detail here.
Let's get more information and
Yeah.
see what plays out.
Yes.
Because it could just come out that, like, it was a hug and I was fine with it.
Yeah, exactly. It could be beyond innocent. It could be, so egregiously okay that the court eventually looks at it and says, there
Right.
is nothing here.
My guess is after they do discovery, the school will file a motion for summary judgment that is going to get granted
Yeah.
on both of the remaining claims.
Yeah, because at that point, the school's going to be able to share their side of the events.
Right.
Yes.
And articulate their legitimate pedagogical interests.
Yeah.
So, like, there are 2 claims that survived that motion to dismiss. We've got the assault and battery claim, and we've got the compelled speech claim. We'll see what happens
So-
with those claims, though. But it's,
So you're
it's
gonna
important to
everybody's gonna have to sit through a part 2 of this, because when this case actually keeps going, if assuming it doesn't get they don't settle and whatever, if we can get
Right.
the actual facts here, I think we should do a part 2.
it would be fun to tell the other side, not the other side, but the court's version of the facts, right?
Of the blanks that need to be filled in. Yeah.
Right. Yeah.
Yeah.
We'll do the Taylor's version of this case.
Okay. All right. So is that it? Is that where are we done?
That's where the case is. Yeah.
Oh my gosh. It's tomorrow. That was a long one.
I've got more if you want.
You've got more?
No, I mean, I could elaborate.
So let's look at the takeaways here, and I don't think we're going to spend very much time on this because we have done, I think, a very thorough job of embedding our takeaways throughout this episode.
A lot of nuggets of wisdom.
Yeah, so I mean, I would just say, listen, as we've talked about on pretty much every show that we've done, you've got to be careful, you've got to be proactive, you've got to, you've just got to be very thoughtful about how you respond to situations, because generally speaking, what leads to these lawsuits is, especially in these complex situations, sometimes it's really cut and dry, but other times in these very complex situations, what tends to lead to these lawsuits is not one bad decision. It's a series of either bad decisions or decisions that just kind of don't sit right with people.
Inadequate responses.
And it's a series of them, right? And if you can sort of, so you know what? Stuff happens. We get it. You're not always going to make the right decision, or the people who, if you're an administrator, the people who work for you are not always going to make the best decisions. That kind of stuff happens. But how you respond to those things is critical. So in this case, there were a number of times when the school or the board or whoever, the associate superintendent, could have taken a different path that might, at the time, it might have felt a little bit more like we are sort of bowing to the parents' requests here. But in the long term, you've got to consider what you want your outcome to be. Do you want to resolve this situation, or do you want to engage in a power struggle?
Right. Do you want to collaborate, or do you want to have conflict?
Right. And listen, there are times when engaging in that conflict and having that power struggle is worth it.
Right. You got to draw the line somewhere.
Right. Exactly. But there are other times where, and I would say in this particular case, it feels like, and again, this is just the parents' version of events, if this is the way it went down, it feels like the school had a number of different opportunities to potentially resolve this situation without it getting this far.
Right. And it sounds like to give the school credit, it sounds like they tried, right? Mom got to talk to a lot of different people to have her voices heard. There might have been issues, though, where the school wasn't talking to itself, right? Where there wasn't clear lines of communications or clear lines of communication of expectations down the chain of command, because it sounds like the biggest issue was people at the school doing things after mom asked them not to.
Right.
And
just because you might have the right to ignore those requests does not necessarily mean that that's the best course of action.
Good. Yeah. Which is the difference between what the law requires and what a responsible, ethical, moral response might be.
And that's an important intersection that, I think we talk about a lot, or we imply a lot on this show, is that there is a difference between those two things, but those two things are constantly in dialogue with one another, right? The law and ethics and morals and whatever.
And you can do both.
Absolutely. Well, I got to say, there is a lot to think about in this case. And I promise you, if we get more information as this thing moves forward, we will come back and give that information to you. So, yeah, great case, Chris. Thank you for grabbing this one. And
it's got some important implications too.
Huge. Love to see how this goes. So we'll keep an eye on it for you, folks. So, what's our homework?
Your homework is to roll the dice. No, we already used roll the dice.
How about double down?
Ooh, that's good.
Yeah.
Your homework is to double down on Chalk and Gavel by going to chalkandgavel.com. You can find our feedback form there. You can find our teaching guide there. We would love it if you would like, rate, and review. Subscribe to Chalk and Gavel wherever you get your podcasts. You can also find us on social media at Chalk and Gavel. We'd love to continue the conversation and hear from you. If you've got ideas for cases, bell ringers, or topics, just let us know.
All right, folks, that does it for this time on Chalk and Gavel. Tune in 2 more weeks where we gather some more low-hanging fruit. And we'll see you then. Have a good one.